national security process and structure. This is a topic that we have very consistently and persistently pursued. It's a topic that we've visited many times because it's something that's vitally important to the national security of the United States, and we make numerous attempts to get it right. Today will be another one of those attempts. We are very pleased to have a very distinguished panel today, and we often introduce individuals on panels as experts and extremely experienced in the area. I can say that with a straight face today because we do have 4 individuals who have a tremendous degree of experience in implementing and thinking about the national security process.
You know, I got the honor of being in the interagency lawyers group, and I got to participate as really the only non-political appointee in the interagency lawyers group. If you think about the other individuals, they're all political appointees representing the administration. I was the apolitical, nonpartisan, uniformed lawyer in the lawyers group. Politics never came into play when it came to our legal opinions, and that was gratifying to me. I don't want to say I was surprised, but I was certainly pleased to see that it was never a matter of politics. It was, what does the law say? What does the law require? What's the right thing to do under the law? We didn't make policy, we said what the law was. And that was consistent throughout my time on the interagency lawyers group, and it was just grateful to see that.
The things that got me thinking about, obviously our topic today is process and structure, is the degree to which your views about process and structure sometimes change depending on who's in charge and whether you agree with the overall agenda. I think that it's probably safe to say that a week ago, quite a lot of the people in this room, certainly not all of them, quite a lot of the people in this room were probably thinking to themselves, hey, it's a really good thing that we have an executive branch that has been willing to use executive power when Congress has gotten in the way, and it's probably a good thing that we have a White House that has been willing to lead even when the interagency process is trying to put the brakes on things or just get past that. I suspect some of the same people are saying this week, gee, I really don't like the precedents that have been set about executive power, and I really hope that the interagency process will be a break on some of the things the next guy who comes in wants to do. And I say that not to just, I think that there's a lesson there, obviously, right? And the lesson is that the process is the process, and we, in theory, as lawyers, ought to have an opinion about what is an optimal process that is not based on who happens to be sitting in the White House. Right, that we don't really, it's not really fair for us to say we like executive power and we like White House-led decision-making when it's one person, but not when it's another person. The whole point should be to come up with a process that we like all the time.
I think that there's, on kind of the micro level, there's a balance between holding meetings, having effective decision-making, having principals from outside the White House come in and kind of spend their time on decision-making that can frustrate some people. I think one of the things we heard sometimes was we did too many meetings and there was too much process. I think that there's a balance to be struck in that regard, but you do need everybody to kind of have to sign on to the concept of the process on the front end to begin with.
Just that the process works well when and only when the players in the process are committed to the process. And I think that we have seen examples in the last couple of decades of times when the process did not work well. And I'm thinking, for instance, early in the Bush administration, the decisions that led to authorization of things such as waterboarding were clearly made outside the normal process. And obviously we later discovered, primarily for those of us who weren't at the heart of it, primarily through documents that were leaked and various post-mortem reports, that many in the military, particularly in the Judge Advocate General's Corps, had voiced vociferous objections that had been sidelined early on. I think the moral of that story is that when senior leaders want the process to work the way it's supposed to, it does. When senior leaders are not that interested in having the process work that way, they can find ways to bypass it. And this doesn't let those of us who labor at the working level off the hook. When people at the working level don't object when they see the process going off the rails, or when they discover that there are side processes going on to bypass the ordinary process, when they don't speak out, bad things end up happening. So I think, the process works when we all make it work at every single level, from the president right on down to the most junior lawyers.
I mean, it's all done by executive order. Every president comes in and will issue their first, it's usually number one, their national security policy document. They'll change the name of what that document is called historically. They sometimes will change the names of the different bodies that meet. And so you've got we currently are using the Interagency Policy Committee, the IPC, the Counterterrorism Security Group is the equivalent in the counterterrorism realm, the CSG. They'll use a restricted CSG, which is an RCSG. They'll have a small group, a deputy small group, and then you have a deputies committee and a principals committee, which would be hard to rename, frankly. And you don't get you don't get statutory bodies until you get to the National Security Council, which is defined by the National Security Act of '47. And so, every president comes in and shakes that up a little bit, the process, whether you have for example, the staff was combined for both the Homeland Security Council and the National Security Council, combined into one staff by President Obama, I think, while Brian was there. And so there's different things they do to enshrine that process. And I don't know that you can legislate that. I don't know how you would legislate it. I think that has to come through practice. It has to come through the procedures and so forth. I think.
David, could I just, I want to take issue with that premise, because in my experience,
The fact that the lawyers...
the notion of the lawyers not being in the room is entirely foreign to my experience. 6 years duration. Now, not all the lawyers were in the room all the time, but I'm having a hard time thinking of an instance in which there wasn't an issue that at its very earliest stages, the legal advisor at NSC would convene the agency council to begin thinking about the issues, and even in a crisis mode, and Brian can correct me if I'm wrong, but I can't think of any significant events where there wasn't at least NSC legal in the room, and I can think of innumerable short fuse issues where he comes out of the room and immediately calls 2 or 3 of us to say, we've got 6 hours to figure out the answer to this question. So, and that's in part my answer to the broader question about how efficiently this works. I would say how effectively it works. I think it's very effective. It's not terribly efficient. There's a lot of effort and multiple meetings and whatnot. But very rarely is there an issue that comes up in the principals and deputies process that isn't early on identified and the lawyers start chewing on it. And if it's a short fuse, you got to chew fast.
I realize this never happens, but what if within the group of lawyers who are working on a particular issue, you simply can't reach a consensus as to what the law is or what the law should be or what action should be taken on the basis of the law? How do you work out that difficulty amongst yourselves?
You're right, David, that never happens.
Are you going to really answer your question?
Yeah, I think even within an agency, it's hard to find 2 lawyers who will agree on a specific question presented. So I think as lawyers, we're kind of used to having to work through differences. And I think one way we try to get to a result, because clients don't want to hear differences. They don't want to hear one agency thinks this, one agency thinks that. They really want to, they want to have something a little bit less nuanced than that for the most part. So focusing on the issues that need to be resolved, the legal issues that need to be resolved in order for this policy decision to be fully informed. And what can we not resolve in a way that would allow the policy process to go forward is one way that we try to stay agile and to make sure we are providing the advice that we need to provide. There's also, of course, on the domestic law side, of course, OLC in our system has the Attorney General have ultimate responsibility. So there are ways to advance beyond just a lawyers group discussion if necessary, but really focusing on the issue that is key to the policy decision is pretty often a way to provide advice that allows for decisions to go forward even where there are difficult legal issues that aren't fully resolved.
Seriously, so it's a good question, and it obviously relates to the role of ODNI in the process. And I come back to the point I made earlier that at least in that species of intelligence activities that we call covert action, there has historically been a direct relationship between the director and the agency on the one hand, and the president and his senior-most advisors on the other. And at least, again, in my experience, the DNI was and should be witting, but was not interposed as an intermediate decision maker in a chain of command. So in that realm, which I think is critically important, but doesn't define the universe of intelligence activities, there's not as big a role for the DNI.